Hey, welcome everybody. Welcome to the webinar. We have now started. It is 12 o'clock Eastern Standard Time. Hello everybody, my name is Ryan. I'm with Halt the Harm Network, and we're just gonna get started in just a minute. We're watching people pile in here, so say hi in the chat and hear me okay. I've got Josh and Ryan on standby. There's two Ryans. Yeah, thanks, Gail. Two Ryans, so you can appreciate both of us, and we'll both just bask in the glory. Yeah, so hi Maria from PA and DE. Awesome. Great to see so many people in here. Marcia from Beaver County, Gail from Communities First, Carrie from Wilmington Township, Anne and Jillian, Mary from Protect PT. Hey Robin, how's it going? Kyle in Michigan. I know I got a lot of responses from the email from people in different states: Texas, Colorado, Wyoming, Pennsylvania, some people in cities like in Philadelphia, some in more rural areas. Rose Noel, welcome. Great. Well, this is awesome. We've just seen in the last like 25 seconds, like 20 more people have joined onto the live webinar. So that's fantastic. And I've got Ryan Hamilton here today giving a presentation. Josh from Fair Shake Environmental Services is also here just to talk a little bit about this series that we're putting together. This is the first in a 4-part series, Halt the Harm Network and Fair Shake kind of partnering together to put on this series. It was based on a survey. Yeah, Josh. So that was actually, Josh and I had a meeting where we talked about that, and we put out a survey, and the answers were so divided 4 ways that we figured, I guess we better just do all 4 topics, right?
Yeah,
So
yeah. I think
that was kind of cool.
the goal was to ask people what they want and give it to them. So they seems like everyone wants. There's a lot to learn right now. There are a lot of fronts that we are working in and fighting against. So we're happy to do a full series where we can spread the gamut and hopefully get at the issues that community leaders are looking for answers for.
Yeah. And Ryan, how are you doing today?
I'm doing good, Ryan. Excited to talk about zoning and some recent cases about it.
Yeah, that's awesome. So I'll just make sure I mention what those 4 topics are.
Yeah.
Today we're talking about the myths and realities of zoning. And oh no, my page is loading. So
I think I can. Yeah, go ahead.
Oh yeah, go for it, Josh. Go for it.
Well, I was going to say, I know that we had talked also about people were interested in state permitting, also and taking enforcement actions, and I don't remember what the last of the 4 was, but I also want to say that I think that we may discover there might be more that people want to know, and we haven't even necessarily said we'll limit it to just 4. If there's more issues that we need to talk about, that's great, and we're going to do it.
Yeah, definitely. Awesome.
Do you remember what the last one was?
I've got zoning, I've got permitting process, evidence gathering, and appeals and challenges.
Okay.
So evidence and baseline monitoring. I'm gonna share my screen now. I've got my my slideshow queued up here. So let me know if you can see it. Should be able to see. Yeah, awesome. So great. So I am just gonna get things started here. Let's see. So welcome to the webinar, everybody. In today's presentation, we're basically going to go through presentation. Ryan's going to give us a presentation. Then we're going to do a Q&A and tell you a little bit about things that are coming up and some of the services that are really connected specifically to this topic toward the end of the webinar. So really, this is all about giving you an understanding of zoning laws, how they impact the development of oil and gas infrastructure. Also, insight into some of the recent casework in Pennsylvania. Although the topic isn't just Pennsylvania only. So if you're in other states, feel free to bring your questions. I'm sure that Ryan will touch on that. Effective strategies on making informed decisions on pollution exposure. I think a big part of the premise here was really just about that if we're, when our communities have assumed risk that we haven't agreed to, right? The risk of exposure to harmful pollutions and various harms. So one of the reasons that I'm so excited to present this with Fairshake is that the Fairshake Legal Collective are lawyers that go beyond the courtroom. I'm going to read this off of our description here. They go beyond the courtroom to give community leaders the tools they need to become equal players in the decisions about their health and future. So that's really what this webinar is about. Community strength against these risks comes from knowledge and action. So that's why we want to understand the laws in place within the local governments that we have access to. That can be an important step into taking back some of our power to make decisions around what we're exposed to. So Ryan Hamilton is the supervising attorney for Fairshake Environmental, the nation's first nonprofit environmental law firm. Ryan's experience is in land use and zoning, oil and gas development, energy law, environmental law, and community development law. Ryan is also a community advocate. He volunteers on the City of Pittsburgh Neighborhood Conservation District's working group as treasurer of the Solar Unified Network of Western Pennsylvania and sits on the Pennsylvania Solar Center Advisory Council. In June 2017, Ryan was named in the Incline's Who's Next Law as one of 12 Pittsburghers shaping the legal community. He frequently speaks to community groups on topics related to environmental, land use, and natural resource law. So without a further ado, let's give a round of applause to Ryan Hamilton. I know everybody's out there clapping, but you can also say hi in the chat. Quick logistics, you can use to engage with us in real time. You can ask questions at any time during the presentation. If you put the questions into this little question area in the bottom of this webinar, then we can actually go through those questions at the end and make sure that everything gets answered appropriately. And of course, stick around to the end because we're going to talk a little bit about Fracking Next Door and this really awesome help center that Fairshake is now helping us to further develop. So I'm going to shut down my screen sharing now and transfer things over to Ryan.
Just wanted to say real quick to add on to the questions. Take a second to vote on the questions as well too, because I will. We're going to have to moderate some of these. I don't know if we'll get to everything, but the votes will help us decide which questions get asked. So make sure you look through other people's questions if you have a chance and vote on them.
Yeah, thanks, Josh. That's awesome.
Yeah.
Great. So we'll turn it over to Ryan Hamilton.
All right, awesome. Thank you so much. I'm going to figure out how to pull up my slideshow here. Just a minute.
No problem. And big welcome to all the people who've joined, even just in the last 5 minutes, where we've really climbed up in attendance, and it's really exciting.
All right, awesome. I think really glad that everyone's joined us for this presentation. I think my slideshow should be up now. Does that look okay, Ryan?
It does. It looks good.
All right.
Screen.
Awesome. So yeah, I want to say just thanks to Halt the Harm Network for working with Fairshake to make this webinar possible. And I think today we're going to really dive into some of what we're calling the myths and realities of zoning protections from oil and gas development. But before we get started, I wanted to just introduce Fairshake a little bit. Ryan's already given us an introduction, but we're a nonprofit environmental law firm. We have offices in Pittsburgh, Pennsylvania, and also Akron, Ohio. but we do serve clients all throughout the Appalachian Basin. We've been lucky enough to work with a number of clients, not just in Pennsylvania and Ohio, but also in West Virginia, Kentucky, and some other areas. So we're really about providing access to justice for people and their environment, and it shouldn't matter what your ability to pay is or what your environmental issue is. You can reach out to us, and we can hopefully provide some help. But before we get any further, I'm a lawyer, so I need to give you my disclaimer. I'm a lawyer, but I'm not your lawyer. So today's presentation is for educational purposes. So what we're going to talk about today, I think Ryan already gave us a good overview, but first we're going to set up just some background on unconventional natural gas development. What is it? Then we're going to jump into a discussion kind of broadly about land use and zoning regulation. What does that mean? What doesn't it mean? Where does the local authority for this regulation come from? And then we're going to jump into some recent court cases and legislation that's affected the municipal power to zone for oil and gas development. Over the last maybe 10 years, there have been some really interesting changes in the law, and I want to look at some of those cases in detail and talk about what that means for the future, really. And then finally, we're going to discuss sort of strategies and tools that community leaders and citizens can use for realizing the long-term development goals of their community. And then finally, we'll have some time for questions, and I'll do my best to try to answer them. And if we can't, we'll find a way to get some answers. So to start, I think it's important to understand that in Pennsylvania, at least, there's sort of been two distinct epochs of natural gas development. The older epoch, known as conventional development, it began over 100 years ago. There's approximately 200,000 conventional natural gas wells that are already drilled in Pennsylvania. But the second epoch, unconventional natural gas development, this really only began around 2004. And the reason for that is that technology has changed, allowing for natural gas to be extracted from mostly from the Marcellus Shale, which is a deep layer of rock, lies about 5,000 to 9,000 feet below the surface, runs from the southern tier of New York through western Pennsylvania, Ohio, and West Virginia. And with advances in technology that allowed for this extraction of gas from this shale, the major difference between that process and the older conventional process is really scale. And when I talk about scale, I mean scale in terms of impact from the development, in terms of truck traffic, in terms of the number of wells that can be sited at any one location, in terms of the amount of equipment that's necessary, the number of emissions from that equipment, the supplies that are used in the process, such as fracking fluids, water, sand. The scale is much larger. And this map here is something developed by the Frac Tracker Alliance. I want to point them out as an excellent resource. This map shows the approximately 12,000 unconventional wells that have been drilled in Pennsylvania to date. And you should absolutely check out their website, something we rely on a regular basis. They do some incredible work tracking really what's happening in these communities. And this is just a screenshot, but they have some really neat interactive tools that you can rely on to learn more. Somewhat related to that, Fair Shakes recently partnered with the Mountain Watershed Association and the Halt the Harm Network to develop what we're calling the Fracking Help Center. And this is an online resource for everyone to access to learn more about the impacts of oil and gas development, to learn about legal processes that are involved, and then to find resources. So if you're looking for more information, I think even this recording today might eventually be available on the Help Center website. So check that out. So jumping into our discussion today, I think it's I always think about the development of unconventional natural gas in sort of three different stages. The first stage is the exploration and acquisition stage. So when we talk about that first stage, we're thinking about leasing. What rights do property owners have when it comes to leasing their property for natural gas development? When it comes to exploration, we're thinking about seismic testing and identifying exactly where these natural gas resources might be. The second stage that we're really going to focus on today is the permitting and approval stage. And then the last stage is the construction and operation stage. And the construction and operation stage for an unconventional well can be broken down into several different phases as well. The first phase is earth moving and site prep. You're often going to see a several acre well pad that's developed with an access road. The second phase of construction and operation is the drilling phase. That's both vertical drilling and horizontal drilling. The third phase is the completion or the fracturing phase, where explosives are actually put down under the earth to open up fractures in the shale rock that's already there. And then the last phase is the production phase. But I think it's important to note that this construction and operation phase is an ongoing process. So for an unconventional well pad, sometimes there may only be 2 or 3 individual wells on a pad. Those wells can be re-stimulated, and that requires returning to the completions and fracturing phase. But additional wells can also be added to a single well pad. So in some instances, we're seeing cases where there's 10, maybe 15 wells being proposed on a pad. In other states, I've heard that there's even higher number of wells on a single well pad. But to focus on our discussion today, again, we're really focusing on the permitting and approval stage. And there's sort of 2 processes that often occur in tandem at this stage, at both the state and the local level. So in Pennsylvania, the state permitting is overseen by the Department of Environmental Protection. There's going to be, for any well pad, there's going to be erosion and sedimentation plans or permits in place. There's most likely going to be a drill and operate permit. And this is where the DEP reviews a casing and cementing plan to be sure that certain standards are going to be met when that well is drilled and eventually operated. You're also going to see waste permitting. In Pennsylvania, the transport and disposal of fracking wastewater is treated as a residual waste. You're also going to have a radioactive waste handling plan, which is submitted to the DEP. And in some instances, you may be seeing the sort of beneficial reuse of that oil and gas wastewater, sometimes being used for fracking additional wells at a different location. And the DEP reviews that and permits that as well. And then lastly, there's just very recently in Pennsylvania, a general permit is issued for new unconventional well sites, which imposes emission limits on a 12-month rolling basis for certain types of emissions. And this is for well pads that have been put into place after August of 2018. I'll also note that there's sort of state environmental performance standards. These are Chapter 78A of the department's regulations applying to unconventional gas development, for protection of water supplies, for E&S best management practices, standards for disposal of drill cuttings, containment standards, reporting requirements in the instance where there's releases or spills on the site, and then site restoration standards as well. And I touch on this only on this one slide, but sort of to set this up as one phase of the permitting or approval process that's occurring, and to differentiate it from the phase that we're really going to focus on, which is the local permitting and approval process through land use and zoning. So let's jump into that. Land use and zoning regulation is really built upon the state's police power to regulate for public health, safety, and welfare. And in Pennsylvania, that authority is delegated to local governments through the municipalities planning code. This is a state statute. And in practical terms, land use and zoning regulation, it's a tool for long-term community planning and growth to ensure that your community and the environment that we all live in every day, it's built and developed for long-term sustainability in a way that prevents nuisance and harms caused by the development of incompatible land uses being constructed in close proximity to each other. So there's a humorous photo of a pig in a parlor to demonstrate that this is what we're trying to avoid with land use and zoning regulation. And I think it's a good starting point to understand that land use regulation in Pennsylvania is really has several different components to it. And it typically starts with a lot of planning, and we call it a comprehensive plan, but that comprehensive plan, for which is enacted by each individual municipality, and there's over 2,500 different municipalities in Pennsylvania. Each individual municipality has the opportunity to collect data about their community, how is land currently used, what types of housing and transportation and utilities issues are there in the community, and how is that expected to change in the future. So it's all about creating a final guidance document that includes this collected hard data, but also sort of aspirations for future growth and planning for the community's long-term development. The second component, based on that comprehensive plan, is development of a zoning map. And this is something you've probably seen. It's a map that effectively divides a community into different sections. And in each section, there's different standards which apply to different types of development. You'll often see a community divided into something like residential, agricultural, and industrial districts. And different types of land development are permitted there and governed by different standards. And where you find those standards, though, is in the actual zoning ordinance, which sets criteria for development. This is legislation which, along with the comprehensive plan and the zoning map, are used to regulate community growth and development. But it's important to know that it doesn't necessarily end there, because even after that legislation is enacted, certain types of development are also subject to a local hearing process. And in that process, the public has an opportunity to participate, to voice support or objection to a proposed development. And ultimately, the municipality decides whether to approve or deny a specific proposed development, and may have an opportunity to impose additional conditions on that development if it is going to be approved. As one example, this map is a zoning map that was implemented by Penn Township in nearby Westmoreland County You'll notice that the township's divided into several different districts. There's industrial districts, there's commercial corridors, there's sort of a rural suburban district. And I only bring this up to use it as an example to see exactly what I'm talking about when we talk about different districts and how they're divided up in a map. I'll also note that in some cases, some communities have decided to use overlay districts as a tool for further defining how development occurs in the community. In this case, you'll see Penn Township enacted a mineral extraction overlay district. And for a number of reasons that I'm not going to get into today, I don't think this is the way that we should be regulating mineral extraction, including gas development. Certainly not through an overlay, but it's another communities are thinking about for defining future growth of the community. So before we jump into the specifics of sort of recent case law, I wanted to touch on a question that I get all of the time. And I think this is going to set the stage for the cases that we're going to discuss. But can local government ban fracking? The short answer is no. And the reason is that Pennsylvania follows a fair share approach to zoning. And this means that municipalities have to assume the burden of providing enough space within their borders for development that meets the needs of all people. And if you think about this in the context of, for example, a community that wanted to prohibit low-income housing or certain types of religious institutions from being developed, you can see how zoning could be a tool for, really not good outcomes. But in this case, in Pennsylvania, the state constitution and the U.S. Constitution generally give us the right to use property without interference. And in the zoning context, ordinances which would prohibit the otherwise legal uses of land may be considered exclusionary or invalid under this fair share approach. So there may be exceptions where, for example, reasonable development of minerals is already permitted or where important public resources would be put at risk. But it's not clear, at least not in my review, that the courts have specifically ruled on that in the context of natural gas development. So I think those are some of the questions that, for municipalities who are trying to really think about, can we ban fracking? Maybe those are questions that they have to answer, but unconventional gas development only started in Pennsylvania around 2004. So this is kind of the start of the story. And in 2009, or just prior to that, there was a developer seeking to put a well in a residential property in the borough of Oakmont. They entered a lease agreement to do that. They obtained a drill and operate permit from the DEP. But when construction started, the borough claimed the operator had failed to get a conditional use approval. And the big question that the Supreme Court addressed in this case is whether the Oil and Gas Act, which is a state legislative statute, whether that preempts the ability of the local government to decide where this activity should occur. And in 2009, the Supreme Court said, the Oil and Gas Act does not preempt local zoning because the ordinance relies on the unique expertise of municipal governing bodies to designate where different uses should be permitted and in a manner that accounts for the community's developmental objectives and character. So at that time, you'll see in 2010 in the Pennico case, it was clear municipalities can regulate traditional land use aspects of oil and gas development, such as location. But between 2009 and 2012, we see a major shift. Around 2012, the state legislature enacted a major overhaul to the oil and gas laws by passing Act 13. And this amended the Oil and Gas Act, and not only did it, it made a couple different changes to the oil and gas laws, but the issues that we're focused on today are the two last bullet points there. One, Act 13 said the statewide rules preempt local regulation of oil and gas development, meaning the state's already dealing with it, so local government, you don't have the power to make that decision. And the last point, not only that, but you must permit unconventional gas development in all zoning districts. So this is a major shift. In 2009, local government had all of this control, but in 2012, the state legislature effectively takes that power away. And for those of you who have been sort of following this story over time, you'll know that fortunately in 2013, that Act 13 was challenged, and the Pennsylvania Supreme Court, relying on Article 1, Section 27 of the Pennsylvania Constitution, found that that Act 13 was invalid. And if you've read Amity and Prosperity, this recent book, that case is a big part of that book. So in Robinson, the Supreme Court found that the state, by enacting Act 13, had violated Section 27 by adopting a blanket requirement to allow unconventional gas development everywhere. And they failed to account for the differences between municipalities and local conditions and the environment that you're going to see across the state. But the question still kind of remained, what does Section 27, what does that provision of our Constitution really mean, and how is it implemented? So the next major case we see is known as the PEDF, or Pennsylvania Environmental Defense Foundation decision. And in 2017, the Pennsylvania Supreme Court took a look at this case. And in this case, you have to go back all the way to 1955, when the Oil and Gas Leased Fund Act was put in place, which required revenue from the lease of state lands to be used for conservation, recreation, dams, and flood control. Fast forward to 2008, and the legislature directed some $300 million from the leased fund into their general fund. So they weren't using it for conservation, recreation, and other purposes under the act. The Supreme Court found this was an improper use of those funds, relied on Section 27 of the Pennsylvania Constitution, and found that they violated their fiduciary duties to conserve and maintain those resources as required. And importantly, for our discussion going forward, the court here notes that all agencies and entities of the Commonwealth, both statewide and local, have a fiduciary duty to act toward the corpus of the trust, those public natural resources, with prudence, loyalty, and impartiality. So the question moving forward then is, how does this Section 27 standard, which is defined by the Robinson and PEDF decisions, how does that apply to zoning regulation in any particular community? And the next kind of big case we see is the Gorsline decision, which was issued by the Pennsylvania Supreme Court in 2018. And this gives us sort of the first indications or answers to that question. And in this case, in Fairfield Township, the ordinance did not explicitly provide standards for oil and gas development, but it did contain a catch-all provision, which is typical, meaning that any development not addressed by the ordinance, any type of development, it has to go through a conditional use public hearing, and the applicant who's wishing to propose or go through with that development has to make a demonstration of similarity and compatibility with other land uses in the location that it's being proposed. And in this case, it was an unconventional well pad being proposed in a residential agricultural district. Now, the court here, based on the record below, ultimately decided that the proposed well pad was not similar to other permitted uses in that district. But the court notes that this doesn't mean unconventional gas development is always incompatible with residential or agricultural uses, but in this case, they found it was. So the next major decision we see come down from the Pennsylvania courts, in this case the Commonwealth Court, is actually a challenge by citizens who challenged the validity of Allegheny Township zoning ordinance, effectively claiming that because this ordinance allows for unconventional gas development in every zoning district of the community, it's violating the rights of those residents who are already living there, who are going to be impacted by this development. And in the substantive due process inquiry, these challengers had to establish that the ordinance was arbitrary, unreasonable, and unrelated to the public health, safety, and welfare. In this case, the court ultimately concluded that where the validity is debatable, the legislator's decision controls. And in this case, they looked to the history of gas development in the township. They looked to recent court decisions, and they found that ultimately they upheld the zoning ordinance. And they told the objectors that your proper recourse is to elect a different board of supervisors who can revise that zoning ordinance and make changes. But I'd note that there were two dissenting opinions to this Commonwealth decision. One of those would have remanded the case back to the township to show evidence that they complied with the Environmental Rights Amendment. And another dissent found that this decision permitting unconventional gas development in every zoning district clearly violated the Environmental Rights Amendment. And it references the PEDF decision, and it, counsels that we need to think about the future of these communities. Right now, that case in the middle of May, unfortunately, the Pennsylvania Supreme Court denied a petition to review that decision. But at this stage, we know that local issues are subject to local control. There's no hard rule about where a municipality may allow or prohibit fracking. So in a minute, we're going to discuss different strategies for enacting or revising ordinances so that they're protective and valid. But if you already have zoning enacted in your community, one really important way that you can engage in the process is to participate in the local public hearing. So in many cases where unconventional gas development is allowed in a community, it's allowed only through a conditional use or special exception hearing. And in those hearings, you'll see an applicant, developer who seeks or submits an application requesting approval, and they have to bring in testimony from their operator, from their engineers, to demonstrate that they're going to be able to comply with the standards that are put in place by your zoning ordinance. In these types of hearings, neighbors are also going to have an opportunity to participate as objector parties and present their own testimony and evidence. And I would note that those objecting parties can also bring in experts. Ultimately, though, the township, they issue a decision, and that decision, it may be appealed by an applicant or an objector. In many cases, it's helpful for an applicant almost certainly has an attorney representing them. And I think neighbors and objecting parties can also be represented by legal counsel. So when going through that local approval process, there's been a very recent decision just at the end of May, which helps us better understand what types of evidence is going to be considered in that process. In this case, the EQT v. Borough of Jefferson Hills decision in that case, the conditional use approval was denied by the borough, and part of that denial was based on the impacts that residents testified about. But in this case, those residents, they were living in adjacent communities, and they were impacted by other EQT well pads, not by the well pad being proposed. Here, the court found that evidence was relevant and probative for determining how residents in Jefferson Hillsborough would be impacted. And this is really important, because before this, it was incredibly difficult, especially where we have this new industry. Remember, again, only really began in 2004. So this is important for understanding how residents can use evidence to demonstrate what types of harms can be expected in their township should this development be proposed. But so this is sort of our final section, because if you've gotten to a local zoning hearing, that means that development's already been proposed, decisions have already been made about where this activity can occur. And what I'd like to sort of encourage today is how to be proactive, how to get involved in this process before development's improved, before development is proposed. So if you don't have zoning at all, or if you've taken a look at your local zoning ordinance and you think it needs to be changed, I'm here to tell you that you can do that. And there's a couple different ways you can do that. Probably the best way would be to run for local government and to make the change yourself as a council member. But another way would be to get together with some neighbors and petition your local government to make those changes. So what I want to kind of quickly go through is what types of changes should you be thinking about, and what types of factors should be addressed in that local zoning ordinance. And I think the number one decision that you have to make, that a local legislator needs to make, is where is it appropriate to site this development? And the cases that we've run through tell us that this is a local decision and it's got to be tailored to the local environment. So in many communities, I think that means that this activity could be limited to industrial areas only. And in that case, you'd be citing unconventional gas development with other like and compatible industrial activities. But once you've done that, once you've decided where this should be proposed, and frankly, I think that decision should be made in reliance on your comprehensive plan, since you've already defined what you want future development in your community to look like through that comprehensive plan. That's something that you can rely on in making this decision. But once you've done that, you've decided where it should go, there's all other types of factors and criteria that you want to think about incorporating into your ordinance. And the goal, I think, is really to learn everything possible about this proposed development and to ensure that the standards set in your ordinance are going to be met, and that there's not going to be any conflicts with other existing land uses or public health, safety, or welfare. So the other issues you need to think about are defining, what do you mean by oil and gas infrastructure? What's included? Are you talking about seismic testing? Are you talking about equipment storage, or are you only talking about well pads? The next question you want to think about is your minimum lot size. In order to not be exclusionary, you need to provide a sufficient area for some development, reasonable development to occur. And you want to think about what type of lot size is required for that. You'll often see a well pad put on an unconventional well pad put on anywhere from a 5 to a 20 acre site with numerous acres of earth disturbance. So that should all be part of the consideration. The next question is, what type of approval process do you want to go through? Or if any, your community, based on your local conditions, may decide that this should be a permitted use, meaning no additional approval process is required. But more likely than not, you're going to decide that this needs to have a public process, this needs to have a public hearing, and that could be a special exception or a conditional use hearing. You might also consider application fees to cover some of the costs of that hearing. And when we're talking about learning everything we possibly can about the proposed development, there's a lot of other requirements and standards that can be put in place as part of that hearing process. Some of the better ordinances that I've seen, or more protective, I would say, they require a number of different studies and standards be met. So in many cases, you want to collect copies of all DEP permitting. You may request that an operator provide a site plan. And in some cases, that might be a full build-out plan. So not just what are they proposing today, but what are their actual future goals for that development. They might need to identify natural features or adjacent property owners and other infrastructure like pipelines that would be connected to that particular development. Another important consideration are setbacks. And in Pennsylvania, the state DEP sets a minimum 500 feet for setbacks, but municipalities can increase that based on their understanding of health, safety, and welfare and the impacts of this development. So in some cases, we've seen communities increase that setback to 700 feet, 1,000 feet, 2,000 feet. It's a decision that you need to make in your community. You may also want traffic studies. You may also want to consider obtaining information about water withdrawal, about plans for disposal of fracturing fluids, of cuttings. How are these materials going to be handled, stored, and disposed of, both on and off site? This is all information that can be contained in your ordinance and can be used to better understand how this activity is going to be taking place. Relatedly, you most likely want to get copies of any emergency response planning, which are required by the DEP. You may also request noise and light management plans. And especially for these types of standards where noise and light criteria, there's no reason that these standards could not or should not apply to every type of development in the community. So if as a community you've decided that these are the levels of light and noise that we're comfortable with, and that applies to every type of development in your community, that's something that unconventional gas developers are going to have to comply with as well. In many instances, I've also seen communities require some type of environmental impact analysis. And I think this is really important, especially for this type of heavy industrial activity. You want to understand exactly what those impacts are going to be. You may also require pre- and post-development soil testing. You may require implementation of a schedule for site prep and the different stages of unconventional gas development. And just like other types of activity and development occurring in the community, you might decide that vegetation and site security are important, as well as ensuring that the township's protected through some sort of certificate of liability insurance. And then finally, when you're thinking about the tools that are really going to help shape the long-term development of your community, you might also be asking questions about this developer's master plan, not only for development in your community, but for adjacent communities. You might also require, as they did in the EQT decision we discussed, that there's a demonstration that operations will not endanger the public health, safety, or welfare, and won't deteriorate the environment at any specific proposed location. I think it's also important to consider including notice provisions, so notice to both the township or nearby residents for different stages of development. In many communities and for many types of development, it's also important to take into account complaint procedures. So what does someone do if they feel that they've been harmed or impacted by this development? And also enforcement provisions. Who has the power to bring enforcement if there are violations? And what does that process look like? These are all issues that can be defined in your ordinance and can ensure that your community is changing and evolving as planned. So the big question that I hope we've tried to answer today is, how do we use these tools to ensure that your community develops in a sustainable manner over the next 5 years, 10 years, 50 years. And land use regulation, it's a very public process. It's enacted at the local level, so individual citizens have immense control. I think that's important to always keep in mind. And when it comes to oil and gas development, the courts, they're telling us that local government has both a fiduciary obligation to protect public natural resources and the environment, and also significant control to tailor their ordinance to local conditions. So I think there's a lot of opportunity here. And the way that you make those changes, like I said before, is to run for office, make the changes yourself, or get together with some neighbors and petition for those changes. And if your community isn't making those changes, you can work with an attorney to help draft a proposed ordinance for your community. But I think the takeaway is it's knowing that zoning, it's all about being proactive. It's about planning now that will have an immense impact on what your community looks like in the long term. So I think that's all I have today. I hope that we've answered some of your questions about how land use and zoning regulation applies to oil and gas development in Pennsylvania. But I'm sure there may be some other questions out there that we haven't answered yet. So Ryan, I think with that, I'll turn it back over to you.
Awesome. Thank you so much, Ryan, for coming on and presenting giving your presentation to us. We got Josh and Ryan still on for some Q&A. So we actually have 22 questions in the queue, and there are a bunch of votes on them too. So we can start right at the top, and then we can go down through these questions and answers. So the webinar is scheduled to go until 1. I'm happy to go over a little bit. And, for those of you that have to leave right at 1, that's fine. You'll be able to catch the replay, but this is a great opportunity for you to get your questions answered directly here live with Ryan. And then finally, I'll also make sure to email you links to Fairshake and to the Fracking Help Center as well, along with the replay. So we'll start right here. You ready, Ryan?
Sure.
Great. So the first question we have today is from Jan. What is the impact of the Pennsylvania Supreme Court refusing to hear the Allegheny appeal, coupled with the Gorse Line opinion that fracking cannot necessarily be excluded from residential areas?
Yeah, good question. So, I think it really depends, right? When the Supreme Court decides that they're not going to hear an appeal, it tells us, one, that the Supreme Court thinks that the lower court's decision should stand, but it doesn't really tell us anything about why that is. So I think what we're going to see, hopefully coming up in the not too near future, is some additional cases that I think are going to tell us, exactly what it means for a community to make decisions about how to zone for oil and gas development. And I think we're still kind of defining what the scope of that power is and how the municipal obligations under the Section 27 of our Pennsylvania Constitution, how they apply to local government making these decisions.
Mm-hmm. Great, thanks. The next question from Megan is, our rural township has an 1,800 megawatt natural gas merchant power plant proposed on 200 acres of ag land. Our township board and PC are stating we cannot block them due to exclusionary zoning laws. What can we do?
Fascinating. So tough to say without knowing more. It sounds like there's we would have to look at the local zoning ordinance to really understand what's in place now. It may be that there's one of those public processes that we talked about, a conditional use hearing or a special exception hearing. It may be that that's part of the approval process for this development, and you can absolutely get engaged in that process. The public has every right to participate. It may also be that depending on whether this has been proposed or not, it may be that there's still time to amend your zoning legislation to maybe not stop this development, but to decide as a community where it should be allowed, if it is allowed. And then I think there's always the state permitting process for these types of activities as well, which there's opportunities for citizens to engage with written comments to the DEP, and if permits are issued improperly, to challenge those decisions.
Great, thank you. Linda has a question. We live in an area where a number of the folks own their gas rights and want the royalty. Getting the local government to pass any ordinance which may infringe on that royalty is difficult. What is being done to set state guidelines?
Interesting. Yeah, and I think that's a situation that a lot of communities in Pennsylvania are facing right now, where there's certainly some interest from property owners to have the ability to lease their gas rights. There's certainly some financial incentives to do that make a lot of sense for some people. But I think, something to keep in mind is that in the context of unconventional gas development, this type of technology allows for both vertical and horizontal drilling. So natural gas can be extracted from quite a distance based on that horizontal drilling. So I think there's still an opportunity for local government to decide, although we're allowing the entire community to lease their gas rights, to still decide where those surface activities actually occur. And as far as state standards related to that, I'm not aware that the state has currently kind of set any standards around that specific question.
Great. Karen is asking, if pending zoning ordinance amendments are referred back to a township planning commission for review and further changes after the public hearing is held, are the ordinance amendments still considered to be pending?
Could you say the question again?
Yeah, if pending zoning ordinance amendments if the amendments are referred back to a township planning commission for review and further changes after the public hearing, are the ordinance amendments still considered pending?
You know what? I'm not sure off the top of my head. It would seem that if the ordinance, or the proposed ordinance in this case, was put in front of the planning commission for review, it would seem that if it was enacted into pending status, that just because there are revisions that go back to the planning commission, I would think it's still in pending status, but I'm not entirely certain about that. And it might depend on the extent of changes to the ordinance. That might be what controls there.
I wonder if the question was, do they need to go through another round of public hearings? And what is the answer to that?
Mm-hmm. There's another question.
Go
ahead.
I was just going to say, I would suggest, if you have a very specific question like that, you're always free to reach out to Fairshake, and it sounds like, if we had a little more detail, we might be able to provide a better answer to that question.
Cool. There's a question about HB 40 in Texas. Said, I actually don't have the name of who put this in. I pasted it in. It came in via email. It says, if Ryan and Josh don't have any answers to this law passed several sessions ago in Texas, it takes away all local control and setbacks. then I don't see a reason for Texans to join in this discussion about zoning. Just being honest, hopefully whatever they have to say for other states will help their communities. Let me know if the speakers have any perspective to give Texans any hope. So I'm wondering if you have any.
Yeah, I apologize. I'm not really sure what's happening in Texas at the moment. So I unfortunately don't have much insight to HB 40 there.
Yeah. Yeah, it sounds like a really tough situation, and maybe something we could try to organize a webinar about. So if
definitely
somebody's paying attention and is, wants to bring that up with us, you can contact me anytime. I'd be happy to work with you on that. Marion has a question. Pennsylvania Act 13. Are municipal setbacks honored when convenient, or does the DEP stick to the 500-foot setbacks as in Act 13? How does the municipality confirm the setback, if at all?
Yeah, good question. So the DEP follows their minimum 500-foot setbacks when they're approving, for example, like a drill and operate permit. But for local approvals, the local municipality can make changes to that. They can't go below that setback, but they can increase that setback. So the way that you would find out about that is either there's simply a standard. Well, there would have to be a standard in the ordinance that defines what that setback is. And so I guess I would first look at your local ordinance. That's going to be the first place you're going to find out whether there is any different setback for it there. And another way would be, again, to participate in this local hearing process where you would certainly learn more about the particulars of any specific proposed development. And an applicant would have to make a demonstration that they're complying with probably not only the state setback, but also the local municipal setback.
From Robin, could you explain how asking municipalities to prohibit leasing public land for fracking is not a ban?
Can you say it again?
Yeah, could you explain how asking municipalities to prohibit leasing public land is not a ban?
Yeah, so I mean, I think certainly if there were a community that was 100% public land, that would be effectively a ban. But in most communities, for example, Allegheny County or some of the townships there, more often than not, the public lands such as the parks or conservation districts are, only a fraction of the community. And there's certainly nothing wrong with prohibiting certain types of development in those areas, as long as overall the municipality hasn't entirely excluded whatever the development might be.
Awesome. Matt asks, does fair share, quote unquote, fair share, somehow require that every legal use must somehow be allowed by a comprehensive plan?
Yeah, I think that's the idea behind it, that as long as you have a legal use of land, that development has to be permitted somewhere in the community. Now that doesn't mean that as a municipal leader you have to sit down and imagine what type of land development could potentially occur, right? Because you don't have to imagine every type of activity. But what you can do, like they did in the Gorseline decision, what you can do is incorporate some sort of catch-all provision and process for certain types of development where they're not specifically designated or identified in your comprehensive plan or your ordinance, but you have a process for incorporating them into your community, and that's how you avoid sort of the exclusionary challenge.
Susan asks, is it better to allow oil and gas use in some zones under CUP, which could then be challenged? Supreme Court and then puts in parentheses Supreme Court May 31st.
I'm sorry. Can you read that again?
Yeah, and also I think Ryan, you could click on the ask a question there, potentially see this as well. Yeah.
All right, that's helpful.
Is it better to allow oil and gas use in some zones under CUP, which could then be challenged?
I mean, I think what I was hoping we are getting across today is that each municipality gets to make this decision about where this is allowed on their own. So if a community does allow for oil and gas development in some zones, I think this means as a conditional use permit, I think that's a decision for the local community to make, and certainly by allowing it somewhere, you're ensuring that your ordinance isn't going to be challenged as exclusionary.
Mm-hmm. All right. Megan is asking for clarification on the meaning of, quote, other EQT operations and not the well pad itself. What specifically other operations did they list? And maybe Megan's referring to a section of your presentation specifically.
Mm-hmm.
Yeah, I think she was referring to the EQT case.
Okay. Unfortunately, I don't recall offhand exactly what I was referring to there, but I imagine, when we're talking about a well pad, there's often necessarily other infrastructure associated with it. So not just a access road and a well pad, but there's going to be pipelines associated with transporting gas away from the site. In many cases, maybe pipelines transporting water or other materials to the site. More often than not, when you have a well pad and pipelines, you're also going to need compressor stations to ensure that gas is moving across those pipelines, and eventually that goes to a processing facility. So I'm not sure offhand whether those were the other operations, but that's the type of infrastructure that would be associated with it.
Mm-hmm. Just look back real quick at your presentation, and I think what you were referring to was like other operations in other districts and other municipalities. So do you want to, I guess that's what the other operations was referring to, that people from other municipalities have important information to give to it in these conditional use permits and conditional use hearings. So I hope that clarifies.
That's helpful. I think what we were referring to there were there was a well pad developed in an adjacent community that residents testified about how they were impacted, and that testimony, that evidence, was considered by the borough of Jefferson Hills. So I believe in that case it was another well pad site. I think that answers it.
Yeah, and Ryan, do you want to go into talk a little bit more about before that decision, what were you experiencing when the communities were trying to have evidence from other municipalities with the same operator?
Sure. So I think that was always a challenge to overcome in these local hearings. Most times the local hearing is very narrowly focused on the particular proposed development. So this is well pad A in this borough. But if you have another well pad in that same borough, or another well pad by the same operator in an adjacent borough, oftentimes any issues that had come up in that historic development wouldn't be considered. They wouldn't be on the table for that decision that was at issue. But following the Supreme Court's recent decision, I think we're going to see a lot more of that type of evidence coming into these cases and playing an important role in it as well.
We have a question from Marianne that says our township has changed all agricultural zoning to rural resource classification. Is that legal?
So maybe not. It's sort of when you're evaluating the validity of any zoning ordinance or any legislation, it's sort of a comprehensive decision that has to look at, how your ordinance functions as a whole, but also, what types of development have historically occurred in your community, and what does your comprehensive plan say about how the future of your community should be developed. So that's certainly another type of question that if you have specifics, we could talk about it another time.
Karen asks, can Pennsylvania municipalities establish setback distances for gas gathering lines in local zoning ordinances?
That's an interesting question. I think it's certainly a possibility. It's not one that I've thought about before, so that's something I'll have to look into.
Yeah, so setback distances for the gathering lines. Gail is asking, isn't there a permit for water use and or protection? And then Josh commented, hey Gail, could you elaborate a little further? So
yeah, there's typically state permitting around like water withdrawal permits. There may be even additional standards when you're in somewhere like the Susquehanna River Basin, where the commission there has control over water withdrawals. And for water use, if you're reusing wastewater for new operations, it's something like a WMG 123 permit. The name something like that at the state level, which would kind of regulate and control that water reuse.
Robin asks, can we talk about the recent Pennsylvania Supreme Court decision on Jefferson Hills and how testimony from residents affected by fracking in other municipalities is now taken into account when approving or denying permits?
We kind of just talked about that, yeah.
Yeah, we kind of touched on that. But I think, to drive the point home, the important thing to know is that evidence is not taken into account unless it's presented in a new hearing. So unless you're presenting that evidence in front of your local board as part of that public process, it's not going to be taken into account. But following that recent decision, it certainly should be if it's presented.
Great. Yeah. And we are working in a community who's placed their overlay district in an R1 zone, stating that since it's adjacent to state game lands, that it's safest there. What's a good strategy to tell them that it's not a good idea?
Interesting. I think this is another one where, we'd probably have to take a look at the zoning map as a whole and what's happening on the ground in the community to really understand what's happening here or why someone might be arguing one way or the other for this. But I think, when it comes to just raising these issues for your municipal leaders, I think it's incredibly important to know that these items don't necessarily have to be on an agenda somewhere, but you're more than welcome to show up at your local government meetings and ask these types of questions and raise those types of concerns.
Susan is asking if there's been thought given to formulas for fairly compensating neighboring homes and those along truck routes for temporary disturbances during construction.
Yeah, that's a big concern that we see in a lot of different communities is just the sheer volume of truck traffic associated with this development is pretty significant. I don't know. That's a good question about how to how to evaluate what that harm is or what the damage might be. I haven't personally thought about that, but that's certainly an interesting question that maybe we'd be able to address in a future webinar.
Yeah.
Wilmington Township residents fought the adoption of an industry-friendly oil and gas ordinance in July of 2017. Dozens of people, including experts, testified, submitted evidence, including a petition and a proposed oil and gas ordinance, which were ignored by the supervisors. Also, prior to the hearing, they adopted a resolution that limited speaking to township residents only. In a future substantive validity challenge, will we be able to enter this in our complaint?
It's a great question.
Yeah, I think so. I mean, if you're bringing a challenge to the validity of an ordinance, the process of enacting that ordinance is certainly the type of evidence that would be considered in a validity challenge. So I think that sort of history about what occurred or what didn't occur would be relevant there, definitely.
Yeah, and I think this directly gets at what the importance of the EQT case. Here's an example of where the speaking abilities of township resident was limited to township residents only, and this new case tells us that we don't have to do that anymore.
Mm-hmm. Great.
So yeah, please reach out to us.
Yeah, Gail's asking, you seem to use fracking and drilling interchangeably, but there's a distinction, correct?
Yeah, there is a distinction. Those are sort of different processes, both part of the development of an unconventional well pad. So the drilling phase is kind of what it sounds like. It's drilling of a well bore, whereas fracking is, or fracturing, hydraulic fracturing to be maybe a little bit more technical, is actually the process where those fractures in the rock are open to allow the gas to escape.
Mm-hmm. Great. Is site remediation required, and can that be a requirement?
So yeah, I mean, under the DEP regulations, site remediation is part of the standards that have to be met for any well pad site. And I think if a local ordinance addresses that, you might be careful about how it's addressed so that there's no challenge that it's already preempted, but that may be part of your ordinance.
And can local zoning control where a pipeline is allowed to be routed?
I think that's a possibility. Again, it depends on how development occurs in the community for all types of uses. So if you're locally regulating where things like pipelines or other utilities can go, more likely than not, it's going to have to be uniform across all types of development.
Gail's asking, why wasn't there training for local government by either government or organizations? Was it difficult to see that would be needed?
I guess I'm not sure how to respond to this one. I think there's certainly instances where, well, I guess I'll answer a slightly related question. I think oftentimes an ordinance might be able to require that there is training for local first responders. I know that's often something that a developer goes through, so they can have an opportunity to hopefully have an opportunity to work with those local first responders and ensure that they're prepared for dealing with any possible problems that might come up.
Great. Matt is wondering if you do legal in all states of the Marcellus, like New York State, for example.
Yeah, I'm not personally barred in New York State, but in other instances where in certain contexts, we can be pro hoc vicet. So we have an opportunity to do legal work, but mostly that's related to litigation. But right now we don't do work in New York, but we might in the future.
And we've got let's see. Our zoning ordinance has, oh, okay. So wait, this is one that we're answering. Looks like some of the other ones all have comments. So I'm going to see if there's any like burning questions. But it sounds like we've gone over 20 minutes with Q&A. Thanks so much, Ryan, for piling through all these questions that we have. There's a few more questions. Oh, here's one more that has a vote on it. Our township threw out our comprehensive plan when drilling hit. So what good is the comprehensive plan?
Well, the comprehensive plan is as good as the municipal leaders who rely on it. Unfortunately, I think it's certainly a guide for future development in the community, and it can be used to support the decisions that you make at a local level. But unfortunately, in some cases, municipal leaders decide to kind of go off the rails and throw that out the window. So, in that type of case, I think there's another really good reason for you to yourself run for local government and make sure those types of things don't happen.
Mm-hmm. Yeah. And one more question. I'm in Colorado, and now we have Senate Bill 181, which gives us local control. This includes zoning control, and I'm running for office to protect us in Broomfield, Colorado. I guess that's more of a comment, but that's awesome from Heidi. And it's great to see people coming in from other states, even though a lot of this content is focused on Pennsylvania. Ryan, since that was a theme that came up, people from other states, is there anything you want to say about how zoning applies differently or how people can get involved in their zoning in different areas?
Yeah, I mean, I think one thing you can take away, although we were really focused on Pennsylvania law here, in every community, zoning is a local legislative issue, and the exact kind of scope of that is going to be different in every jurisdiction in every state. But I think the takeaway is that, as Heidi mentions, zoning's about local control, and as members of the public, you have the power to get involved and make those changes. So,
Awesome. Well, thank you so much, and I'm going to wrap up the Q&A now. Thanks, Ryan and Josh, for working with us here at Halt the Harm to do this webinar. For everybody that's new to Halt the Harm Network, I'll send you a few details, but the basic sort of gist of it is like we're a platform to help people who are concerned about oil and gas issues, who are taking leadership, who are wanting to get educated or educate others. We're a platform to network and connect with other people, for you to share your skills, for you to learn from others. And so you can get all the information at halttheharm.net about that. Just check out the homepage, kind of browse through some of the services that the network is offering. All the services, including this webinar, are offered by people in the network. So the best way is to just get involved. And really, that's all I have to say about Halt the Harm. And we're really excited about the Fracking Help Center as well.
Yeah. Thanks, Ryan, for having us on. And I just wanted to say there was a number of comments in the chat window about getting the copy of this presentation to give to community members. We're happy to do that, and Ryan, we can talk with you about making sure that's included in any follow-up email. But also, if you're in Pennsylvania and if you're in Ohio, possibly too, send us an email. My email is in that chat. It's jeisenfeld@fairshake-els.org. and reach out to us. We'd be happy to work with you to try to actually come to your community and give this presentation. We rely on community leaders like you to tell us, how we should be using this, because it needs to get into your hands. And if you can be that liaison to get us into your community to give this information, we'd love to do that. So please let us know.
All right. Well, that wraps up the presentation, and thanks everybody for tuning in. And for those of you who stuck around this far into it, that's awesome. We still have 44 people on live. So
awesome.
So I think we're calling this a big success, and we'll get the replay out as soon as everything's done loading and saving.
Awesome. Thank you.
Thanks, Ryan.
Take care. We'll be in touch.